Good morning and a very warm welcome to the India ADR week. We will be starting with our first day with an opening address by Honorable Justice Somasekhar. I would request Mr. Farid Karachiwala to come on stage to introduce the judge. Thank you.
Can we have everybody settle down, please? Good morning, everyone. It's my absolute honor and privilege to introduce Justice Somasekhar Sundaresan. After having spent 25 years in practice, being a part of two law firms, he actively went into counsel practice and became a judge of the Bombay High Court. His expertise when he was a counsel ranged to a variety of matters: securities law, financial law, commercial law. When he exited the law firm that he was last in is JSA Associates, which then inducted me as a partner. So absolute honor and privilege, and may I request Justice Somasekhar to please address the audience.
Good morning, everyone. When there was a discussion to do this session, I was wondering who would show up at this unearthly hour in the middle of a week. But thank you for coming in and listening in. I will very briefly touch upon some of the experience that I've had in the context of the theme of what you're going to discuss over the next 2 days. Arbitration in its landscape has been a very satisfying experience for me, sitting as a roster judge in the High Court, a role where the interference and the involvement of courts by law is meant to be at a minimum. And but when I look at the landscape and look at things that trends that are emerging in arbitration, I thought I'll share some perspectives in that light and see whether we are geared to live up to the expectations of this legislation, because it's a very important policy intent behind the legislation. I believe every legislation has a policy perspective. There's no legislation without an underlying societal objective. And Arbitration Act, the Arbitration Conciliation Act is no different. What I do want to talk about is, are we fashioning ourselves in the conduct of arbitration in the manner that is expected to be of value addition to the stakeholder, which to my mind is primarily the litigator, the litigant who seeks to have disputes resolved and comes into, agrees to arbitrate, reposes faith in the arbitration system upfront by contract. And when the law says party autonomy trumps everything else, what the law essentially recognizes is that it is the litigant who's made a conscious choice, and that choice to go in for arbitration needs to be respected, and he gets returns from that choice to the best extent that the system can throw at it. So are we as a bar, or are we as an arbitration community able to live up to that expectation is something I would like all of you to reflect upon as an abiding theme. I did go over the topics that you're going to deliberate upon over the next 48 hours. Mediation is something you all are going to discuss, and I found to my pleasant surprise that whenever we sent disputes to mediation as a precursor to arbitration, almost in 6 out of 10 cases, I mean, it's again anecdotal and not really empirical, but a significant component would come back to settle. And they would say that, look, thank you for referring us to mediation, and we've settled. So which led me to another approach to essentially say that when people are struggling to even have an arbitrator appointed, some of the Section 11 proceedings would be pending for years on end, and one has had to think about means to devise speed with disposal of 11s. But what innovation I felt was appropriate would be to say that we'll appoint the arbitrator, but give a deferred effect of 4 to 6 weeks, depending on the nature of what is being presented by the parties. to say that we'll give you, here's the arbitrator will start proceedings, but we'll give you 4 to 6 more weeks to try and resolve. If you don't resolve, the arbitration will start. And there too, I'm happy to report that in a number of cases, parties would settle or come back in the 4th week or the 3rd week and say, look, thank you for that deferred effect. We just need 2 more weeks to allow us to defer the arbitration further by 2 weeks, which again indicates that mediation as a means of resolution is something that really works. But how does one make this work professionally? How does one make this work in a manner that's consistent with the Act? How does one look at mediation and conciliation in a formal process manner, work effectively, is something I hope all of you would reflect upon in the session that you have on mediation. While on mediation, I must touch upon the MSME Act. I mean, the MSME Act is meant to be a special legislation which has got protective features for medium, micro, small and medium enterprises. And this would be the future conglomerates of India, hopefully, if the market economics choice that we made as a policy works. And they get certain specific special treatment in terms of a better interest rates in recovery, etc., which is meant to be a disincentive. Likewise, a 75% deposit, which is meant to be a disincentive to challenge those awards lightly. But again, the society reacts. Like whenever there is affirmative action in favor of a certain component of society, the embedded assumption is to say, all right, why this special treatment, why this appeasement, we must adjust for it. So the 75% gets computed as 75% of the principal amount awarded, not of the interest awarded. You take any other legislation in the societal sector, special laws for protection of women or children, the system adjusts to do justice because it feels the law is not just and we should try and adjust for it. I'd again encourage all of you as the bar to reflect on it and see whether this is something that would, in the long run, erode the arbitration field. Of course, there's no perfection, but with judgments come improvements. And the MSME Council may not be adequately trained and they may not be delivering the best of awards, but with case law, with reviews that take place, it would evolve even further. So I'd again request the arbitration bar to reflect on how we handle MSME awards. Can we participate in those councils more? Is there something that law firms could do to engage with facilitation councils, do capacity building sessions with them, and try and see that you raise the bar and the quality of the awards that come from there, rather than just see how do we hit and run. So essentially, the protectee of that legislation should not get those protections eroded without eroding the principles of fairness and justice, is a thought I want to leave behind. Then I see that you're going to debate India's evolving bilateral investment treaty regime. Again, a very, very important controversial subject. In my days as a lawyer, I've been an expert witness in one of these treaties, sitting at the, I don't know what room that was, a palace room or a Japanese room or whatever at the Hague. And this is again an area which needs a lot of study. There's no syllabus that covers it. The philosophy behind bilateral investment treaties and whether a private arbitral tribunal can resolve disputes between constituents of two republics are the larger philosophical questions that may be debated. But when a treaty has been signed, a party has the power to invoke that treaty and that arbitration does get underway. What is the capacity, what is the bandwidth that we as arbitrators bring to bear, or we as arbitration bar bring to bear, is something that I'd like all of you to think about. I know I still use the we for the bar, but I do think that lawyers and judges are part of the same ecosystem. A judge is a lawyer who's chosen to be a judge. So when you look at the arbitrators in these BIT treaties, I don't see many Indians on the panel. What can we do to get onto those panels? How do we build capacity to ensure that there are Indian arbitrators in these tribunals looking at disputes between two large, far western republics, is something we should think about. The quality of cross-examination, the quality of witness evidence that is led in these arbitrations is something maybe forums like MCIA should run special workshops or do case studies and examine how it's done. But the other element I want to leave behind is you have to just see how some of these arbitrations are conducted to see the time value of money in litigation. If each party is given a time allocation, that party decides how to use the allocated time, and the clock stops, the guillotine stops. I've tried to make a very small start with time allocation in my roster with reasonably good success, though I do realize that it leads to a bottleneck at my end because more and more matters get done and then the onus is on me to then convert that into a judgment. But again, we have to raise the bar here. If there is a case management hearing and there's an estimation of time, the expectation would be to have a realistic feedback of the time. The estimation should be based on real issues that you intend to articulate. You come back and say, these are the 5 issues that we need to discuss. This is the kind of time we need per issue. That's what a case management hearing is about. I find that it's quickly getting into, all right, this guy likes to hear 45 minutes or 30 minutes. We'll say 45 minutes, 30 minutes. How is he going to stop us beyond a point if he can see that it needs more time? So again, I'd encourage you to, before you come in for a case management hearing, like with these international forums, think through the issues, the key issues, the sub-issues, the time needed for each of these, and then come with a realistic estimation of time so that the case management can meet international standards. From the BIT, at the least, what we can learn is the professional standards that get deployed in the course of really high-stakes arbitrations that take place. Then you have an interesting theme called, are you interviewing your arbitrator? Changing the mindset in the Indian landscape. There was a time when lawyers being interviewed for being recruited was considered ridiculous. I mean, it's a noble profession after all. How can the client expect the lawyer to do a beauty parade? What kind of profession is this? Are we a profession that's intellectual and going to give service, or are we here to show off and burnish our credentials and polish them and present them in a marketing of our resources? But the truth, as in all cases, lies somewhere in between. You don't need to market, you don't need to promote, you don't need to self-promote, which of course you just have to log into LinkedIn and you see how many lawyers express emotional satisfaction at having won a matter or having closed a contract. So lawyers are out there burnishing their credentials and polishing it and showing it to the world. But look, the flip side is, are we delivering value, and how do we examine that the client is satisfied that the person he recruits is someone who can deliver value? Now, shift this to the arbitrator scenario. Party autonomy is what underlines choice of arbitrator. How much do parties get to appreciate the qualities and the capacities of the arbitrator who would decide matters that are being referred to arbitration? This is an important question. To the extent possible, as a judge holding the Section 11 roster, I try and apply my mind to the nature of the dispute, to the value involved in the dispute. It's very easy to dispose of these applications appointing an arbitrator, but if the cost-benefit ratio doesn't work, arbitration would fail because people would say that, look, it doesn't work. The arbitrator would be frustrated beyond a point where fees are not paid and he would resign and then you would substitute. And all this is happening at the expense of the litigant. And therefore, I'd encourage you all to encourage your clients to think about, to the extent possible, upfront, agree upon the identity of an arbitrator or agree upon the identity of the process by which you choose the arbitrator. The process for choice also has specific sections in the Act, but I suspect nobody ever reads those provisions and applies their mind while negotiating a contract as to what is the procedure for appointment, what is the procedure for conduct of the arbitration. Most arbitration agreements are wholesomely silent on these facets of the matter. In which case you then depend upon institutional arbitration, forums like MCIA or even the algorithm-based service providers who are now adding value, particularly in low-stakes matters, high-volume matters. What is the nature of the choice that a client gets to exercise while appointing an arbitrator is something that lawyers need to apply their mind to. Not every person is equipped to handle a sophisticated trial, because remember, when you choose an arbitrator, you're not choosing an ultimate appeal court. It's not a retired Supreme Court judge may be excellent in disposing of the matters that come to the Supreme Court, because by the time things come to the Supreme Court, 2 or 3 layers of judicial review have taken place. Issues that come up at that level are finely distilled, and therefore dealing with that distilled issue is one skill set. But dealing with a whole full-blown trial is a completely different skill set. So you may have the dichotomy of a bar which has never conducted trial, because the bar is practicing in the High Court, not in the district courts, not in the trial courts. The original side of the High Courts may be so overloaded that actual trial on a day-to-day basis does not take place enough for bandwidth for the bar to develop. That bar becomes the bench, that bench goes higher, and then they suddenly become arbitrators having to conduct trial of a complicated dispute. This is something that we need to introspect on. How do we build bandwidth? Do institutions like MCI go to the district level and identify talent? I mean, in one of my discussions with the MCI team, I wanted to understand how they look at the catchment area. How do they look at having the best panel possible? Where do they go and scout for new talent? And I'd encourage all of you to think in these terms. If you know of great trial judges, trial lawyers, bring them into the arbitration ecosystem. That's very important for the wider good of the arbitration landscape. And of course, as counsels, as advocates who argue, you may be able to argue, but at least the forum that you argue before, if it doesn't have hardcore trial experience, you could end up having a reasonably complicated outcome in an arbitration. And that award may be set aside 5 or 7 years later, in which case you're like a snake and ladders game, back to square one, which again takes you to the other subject about modification. The last word has been spoken as of today on modification by a much larger bench of the Supreme Court. And therefore, this is something that you need to think about, whether at the very genesis of the arbitration, when we select the arbitrator, is that arbitral tribunal a relevant horse for that course? And will it be able to run the process in a manner that gives best value for the client? This, most of what I've said also touches upon the focus on the client theme that one of your sessions intends to talk about. I just want to leave this thought behind. Ultimately, in every ecosystem, the stakeholder's experience is what matters. The stakeholder decides whether the ecosystem is working for him. If the ecosystem doesn't work for him or her as a stakeholder, the stakeholder moves to a different ecosystem which works. In the darker side, the stakeholder would move to settling matters by taking the law in his own hands if the justice delivery system doesn't work. On the brighter side, in the economic sphere, the stakeholder would choose a market which prices that asset better. This is what is called arbitrage in economics. And the stakeholder would move markets. So you would have stakeholders going away to other cities within this country or going away to other jurisdictions outside this country enforcing Indian law. So it's not for nothing that Singapore has positioned itself as a forum regardless of the proper law of contract. So people can go there. Dubai is trying to do the same. So we need to think long-term on the stakeholder satisfaction facet. If the stakeholders are dissatisfied, we wouldn't have a market left to deliberate upon and discuss. So I just want to leave that thought behind. Thank you very much for listening to me. And again, I'm sorry for this unearthly timing of this session. It's really 8:30, 8:45. It's really early in the morning on a weekday. Thank you for having me.
Thank you, Honorable Justice Somasekhar. We truly appreciate your valuable insights. I would like to request Mr. Vyapak Desai, MCI co-chair, to come on stage to deliver the vote of thanks. Thank you.
Good morning, everyone, and thank you for coming. As we ended Justice Somasekhar saying it's an unearthly hour to come for this session. So looking at this session fully booked and fully full, I think definitely things have changed. When I started the practice and I used to talk to a lot of senior people, they used to say, change the way you look at things and things you look at change, right? I think that's what ADR week is all about. That's how we set up MCIA to see that if institutional arbitration, can we see arbitration differently and can arbitration change in itself? I think we have come a long way, and thank you, Justice Somasekhar, to give such an inspirational speech. And like he does his case management hearing, he asked me how much time I should take in. I said 15 minutes, and he actually covered the full topic, full ADR week in that time. So it's possible, if we do a case management hearing, it's possible to cover most of the topics, and it was truly inspirational. In fact, while ADR week and MCIA has started more than 7-8 years now, but since his roster, I think it has given a complete new sense of confidence and perspective that arbitrations, particularly because of Bombay High Court and the support he has given, we can look at a very different level, very different perspective, and without too much of interference. He has given the kind of support that MCIA possibly needed for a very long time. So thank you for everything, Justice Somasekhar, and without much ado, maybe we can straight away go into the session. Thank you again. Can we give a very, very big round of applause to the session?
Thank you, Vyapak. Our first session will be hosted by JSA on the topic of mediation in the realm of ADR. The session will be moderated by Mr. Farid Karachiwala, and the speakers include Honorable Justice Akil Kureshi, Mr. Janak Dwarkadas, Mr. Shrivardhan Deshpande, Ms. Shwetha Bidhuri, and I would request the speakers to kindly take the stage. Thank you.
Once again, good morning. Just a minute to introduce my panelists and myself. My name is Farid Karachiwala. I am the co-chair and a partner in the disputes practice of JSS based out of Mumbai. To my left is Justice Kureshi. Justice Kureshi, after having practiced at the bar, became a judge of the Gujarat High Court and then retired in March 22 as the Chief Justice of the Rajasthan High Court. He was also the Chief Justice of the Tripura High Court. To his left is Janak Dwarkadas. I don't think anybody in the audience needs to know as to who Janak Bhai is. Janak started his practice in October 1977, became a senior advocate in July 1997. As somebody who does litigation, I would like to say that there's just nobody who wouldn't think of Janak to be involved in a matter which he wants to litigate in the High Court. To his left is Shrivardhan Deshpande. Shrivardhan Deshpande is the legal head of the Mumbai Airport. After having practiced in a few law firms, he went into the corporate side of being involved, and he's right now the legal head. He's been the legal head of the Bombay Airport since the last 2 years. To his left is Shwetha. Shwetha is the director and the head of SIAC. Now, of course, the topic is mediation, but I thought that she could give us a perspective about how an arbitration institute views mediation and whether they are threatened by mediation to that extent. So she's going to give us that perspective from the institutional point. Let me start off the question so that we have enough to speak about, and then we would probably take a few questions from the audience. I'll start with Justice Kureshi actually. So in your experience as a mediator, how effective is mediation as a form of ADR?
Thank you, Farid, for having me here. I would say mediation is extremely effective. You cannot go by percentage in how much of success you have received. Out of 10 matters, how many are you settling? But one settlement stops several litigations. And particularly, I've seen three flavors of kinds of disputes which come for mediation. One is purely commercial, where there are no emotions involved. Two parties who are on commercial terms have a dispute, they go for mediation. Other is purely family disputes, where there are highest levels of emotions, husband-wife disputes and such like. But in between come the most difficult part, where the family has done business together. So the family emotions are involved and the business stakes are also involved. In one of the matters which I could resolve, there were 12 pending proceedings between husband and wife, all kinds, the worst kinds, and at least 5 more in pipeline. So also in commercial matters, we know one matter is not just a single proceeding, there are several disputes, and then there are litigations, there are appeals, there are revisions, there are executions. So don't go by the numbers. Even if we settle 1/4 of the total matters which come before us, it's an outstanding result, because that stops a lot of litigation in future also coming before the courts. So I believe it's very effective. Still, we need to do better. We need to have more and more people coming for mediation. And the key to success of mediation, Farid, is to select a matter which is possible of settlement. Okay? That's where the lawyers and the courts can play a very positive role. Find a matter which has a potential of getting settled. Thank you.
So just continuing from that thought, what according to you are the causes or the prime causes for failure of mediation? Because like you said, you need to actually go in for a matter or go for mediation where a matter could be possibly settled. But of course, just as Somasekhar said that out of 10 matters that he refers to mediation or the High Court refers to mediation, 6 get settled. But what, according to you, in your experience as a mediator, are the prime causes of failure of mediation? Is it the mindset of the parties who are just not interested in going into mediation or participating fully into mediation? What, according to you, would be the prime causes where instead of, say, 6 matters out of the 10, we could have a higher number?
3 prime reasons, according to me. One, involvement of too much of emotions, ego. I do not want to give in. I do not want to give up without a fight. Sometimes it goes to the extent of, I'll destroy him, even if I get destroyed in the process. So if you can eliminate the ego or the hurt feeling, sometimes, even in commercial matters, we are very emotional people, the Indians are. And therefore, one aspect is, if there is a lot of emotions involved, then there is a lesser chance of success. 2, the highest chance of success of mediation is where, because of the pendency or prolongation of the litigation, both sides are going to lose something. If in a proceeding where I lose nothing and you lose everything because of the pendency, very little chance of it getting successful. If I owe you some money, if the matter goes to civil court, I'll say I'll see you after 10 years. Why should I settle? Why should I mediate? And the third aspect is, frankly, too much faith in the Indian legal system. People say, if I don't succeed here, I'll go to the court and get the order. Not realizing that how difficult it is in sheer time consumption. And effectively, therefore, if they don't mediate now, if they don't settle now, they come back after 10 years completely tired, drained of the resources, and ultimately settle. So all the times I say, if you don't settle now, you come back after 10 years and you will anyway settle. These are the three main causes, according to me, are the reasons for failure.
Thank you, sir. Janak, I'd like to get you involved in the next thought that I have on this discussion. That Justice Kureshi mentioned the prime causes of failure. Do you think that they should be, and I know that you've participated as a mediator in a couple of mediations, which you told me earlier that they were not successful. But do you think that there should be consequences where a party does not participate in the session or in the process when, this could be an effective way of resolving disputes?
Thank you, Farid. Thank you, MCI, for inviting me for this ADR week, and thank all of you for being here early in the morning and participating in this seminar. To answer Farid's question, I had told Farid when he asked me this question, how successful have you been in settling disputes in mediation? I said my record is rather dismal. I was appointed mediator in 2 disputes, both of which I had to put in a failure report. So I would not be the role model or poster boy of mediation. But to add to the 2 was yesterday when in court, again, there was a dispute, not dispute as Justice Kureshi mentioned, several disputes involved in the litigation, more than 10 if I think correctly. And I was asked to mediate by the court. And unfortunately for a very, very small and marginal difference, and probably for the reasons which Justice Kureshi just outlined, probably all 4 of them. I mean, I noted them out very carefully. Ego, emotional attachment, litigation delays, and faith in the legal system. I think probably all 4 played a role, if I may put it that way, in why, even though the difference was hardly anything, and I can tell you, the difference was so small that 1 day's cost to the parties, 1 day's cost. There were 40 lawyers engaged on the 2 sides, including at least 5 or 6 senior counsel on each side. I think the average cost of a day's hearing was about 2 crores. And the difference for which the mediation failed was not even 4 crores. I mean, it is insane, let me put it that way. As luck would have it, a connected matter out of the 10 went to the Supreme Court and reached in the evening yesterday afternoon. And Justice Karachiwala said nothing of the kind. They told the court that there was an attempt to mediate the dispute in Bombay and it failed for a very small difference. He said nothing doing, you will go to Justice Oak. I'm referring all the disputes to him and get it mediated. So to answer Farid's question, it's a very important question he has raised. Do you think if there are consequences, would it help? Now, according to me, there are 2 ways in which you can look at it. In some jurisdictions, you have a consequence where if a party does not make what is called reasonable efforts to mediate, there can be some consequences visited on that party in the ultimate outcome if the matter goes to court. So that is one kind of a deterrent on the party trying to scuttle mediation or avoid mediation, because as you know, under the Act, the other party can just refuse to participate or participate in a half-baked, half-hearted manner, knowing that at the end of the day, if I am a defendant and I have to pay up, I would rather take advantage of the delays in litigation than try to resolve it, because I know that the plaintiff has to wait for 15 or 20 years to get the reward. So that is one way of looking at it, that you penalize a party for not making reasonable efforts in trying to resolve the dispute through mediation. But according to me, and this has been my belief for a long time, the more important deterrent or the more important consequence which we ought to seriously undertake, considering the fact that litigation today sometimes is more than a luxury, much more than a luxury, and it only favors the defendant at the end of the day, or the defendant or the dishonest defendant, if I may put it that way, who does not want to honor the contractual commitment or whatever obligations he may have undertaken. I feel that the only way in which things like mediation or any kind of ADR would succeed is the losing party having to pay the actual costs of the party winning the litigation. Until and unless we adopt this model, I'm sorry to say, sometimes when courts do impose costs as a penalty for recalcitrance or for adjournments which are unnecessary or for dragging on a proceeding without just cause, and say a figure of, I'll give you a recent example, I won't take any names. The costs of 15 lakhs were imposed on a litigant who took some 2.5 years to file some affidavit or the other. It became a talk of the whole library in the High Court, and there was so much hullabaloo. What does the judge mean, 15 lakhs? I mean, what the, frankly, I thought it should have been much more. You know, you can't take the courts for granted. There are litigants who are waiting for years together. You take it your own sweet time, come after 2.5 years and ask for an adjournment to file some reply. There should be costs. Why should not be a cost follow the event? So I think if you're asking about consequences, yes, one could be, as I said, not participating can result in consequence. The other is, all right, you go through litigation, avoid the mediation route, end up paying not only your lawyers, your solicitors, and the time that you have wasted, but even paying the costs of the lawyers and solicitors of the other side at actuals, and see how mediation becomes suddenly very effective. Thank you.
Thank you, Janak. Just to take this thought further, our Mediation Act, which came out in September 2023, we are 2 years from the time that the new act came. This actually kind of required a voluntary participation in mediation. When we look at the earlier bill of 2021, it kind of mandated that a party needs to go through compulsory mediation before he can initiate a process in court, very similar to what we have in the Commercial Courts Act. But finally, what was enacted by Parliament was not making it mandatory, but making it voluntary. Do you think that the approach of the Parliament of making it not mandatory, but making it voluntary, kinds of puts it, a shadow back in terms of how disputes could be resolved, especially when we have so many courts in our country, including the Bombay High Court, which is facing the largest backlog of cases which are to be heard. Do you think that we've taken the right step of not making it mandatory before initiating, or do you think that the approach of the Parliament of making it voluntary mediation is the way it should be?
Thank you, Farid. Again, a very important point raised by you. I mean, look, if you look at the objects and reasons as to why Parliament thought it fit to bring in mediation as a mandatory pre-institutional requirement, it says in so many words that it is to take the burden off the courts. That is one. And the second is that commercial litigation deserves a priority in the sense of it deserves commercial disputes required to be resolved in that sense faster, because commerce cannot afford to wait for 10 years or 15 years or whatever it takes. But I don't see any logic in saying that commercial disputes, you make it mandatory pre-institutional mediation and keep all the rest on the back burner. There appears to be absolutely no rationale and no sensible reason to make non-commercial disputes pre-institution mediation non-mandatory. I think the Parliament ought to have accorded the same sentiments and required the same, given the same importance to mediation, because if you really wish to promote ADR, you really wish to lessen the burden on the courts, then it doesn't make any sense to say that pre-institution mediation in respect of commercial matters will lessen the burden, but the other litigants can wait for whatever time it takes. I think this requires a rethink. And I may just tell you I was looking at some of the provisions in other jurisdictions of the world. I found Italy since 2010 has made it mandatory in certain categories. Brazil in 2015 has amended its civil procedure code mandating pre-institutional conciliation or mediation. Singapore has done the same. The EU framework has done it since 2008. And UK and US do not have a mandatory universal mandate, but the courts compel the parties as far as possible to undertake mediation before taking up trials. But again, I must emphasize once again that don't forget, in these jurisdictions, ultimately the courts do impose costs on the losing party at actuals. So when they talk of mediation or they talk of pre-institutional mediation, the party knows beforehand that if it does not take this chance and bring about a settlement through mediation or conciliation, there is a price to be paid at the end of the day. And also, look at it this way, the statistics, say in UK, I don't know about other countries, I have not studied it, but I am told that because of the consequence of the losing party having to pay the costs at actuals of the winning side, not even 4%, if I'm not mistaken, probably the statistic is even lower today, but at one time, not even 4% of the cases filed ultimately went to trial. So you can just see, if 96% of the cases which are filed are resolved through an ADR mechanism, can you imagine the burden that would be lessened on our courts? Thank you.
Janak, I think your point is well taken that in order to make it successful, there should be not only a full ecosystem where the legislation, the judiciary, and everybody participating, including advocates and litigants, understand the consequences of not participating in the process fully. I think the other point that I would like to take on our act is, although India is a signatory to the Singapore Convention on International Settlement Agreements to recognize mediation, but that again has not been imbibed into our legislation, and to that extent, international agreements which are reached between parties are not recognized and enforced in India. Do you think that also is something which is, I think, lacking in our act in order not to provide for international agreements, especially when India, the government, one of the biggest litigants in the world, we are looking at so many disputes in every part of the world, and the act that we have enacted is not having this recognition. Do you think that we felt or we have fallen a little short of expectations from the global community? And being a signatory to the Singapore Convention, we have not taken those effective steps in our act.
I mean, frankly, again, there are so many areas where we are lacking in our approach and attitude towards ADR. I think we seem to be always moving in the direction of one step forward and 2 steps backwards. I mean, recently, what the government of India has done by issuing the circular with regard to arbitrations and its approach and telling government and government institutions that why should you go in for arbitration at all? I mean, I can't even imagine what could have prompted the government to give this stepmotherly treatment to ADR in the first place. Now, if that is the mindset and that is the thinking, is it surprising that we have made mediated settlement agreements mandatory under the Act, but restricted it only to domestic agreements of this nature? Why should it not be bilateral? We are signatories to the Singapore Convention. Why have we not affirmed that part of the convention and made it part of our law. Of course it should be done. It will encourage parties to, who have entered into these settlement agreements on a bilateral basis to have ADR taken up and a mechanism adopted. What is happening is, we are, as I have said in some other seminars, India is not only in that sense lagging behind in pursuing ADR, but what is more important is India is exporting arbitrations. Our biggest export today is arbitration. I think Trump should put some tariff on that also, according to me. If you see how many countries are benefiting by the fact that our arbitration mechanism itself has become so slow with the interference by courts, that people are opting to take the disputes outside the country, and it's happening regularly.
Janak, your point can be confirmed by Shwetha.
She's one of the beneficiaries to my left.
Singapore International Arbitration Center is, I think, India is their biggest client. I mean, in terms of disputes that SIAC handles, isn't India the biggest market so far as arbitrations are concerned? And I want to talk a little bit more on mediation and how you view it, but from the perspective of Singapore, I did a little bit of reading while preparing for this. Singapore set up its mediation center in 2014. It also set up its mediation institute in 2014. In 2017, they came out with their law on mediation. In 2019, the United Nations had this agreement on international settlement, recognizing mediation settlement, which was signed in Singapore, which is why it's popularly known as the Singapore Convention. But Shwetha, again, is India not your biggest market? One. Two, how do you look at mediation as a threat to your institute as arbitration? Now, while I have read a lot about mediation and arbitration actually going hand in hand so far as Singapore International Arbitration Center and Mediation Center is concerned, but from your perspective, and I know 85 to 90% of the matters which actually go to Singapore Mediation Center get settled. How do you respond to these two questions about, one, what Janak said, that India is the largest exporter of arbitration, and two, as an institute, and an arbitration institute, how do you look at the mediation center to being a threat to your institute?
I think both very important questions, and thank you for having me here. I'll start with your first question, which I think Janak put in the spotlight. India is one of the top foreign users for SIAC. But I think, we hear this quite often in the recent times about cases from India going to Singapore, or, the word of exporting cases which could have ideally been adjudicated in India. But look at the large number of, what are those cases? These are international disputes, which means one of the parties is a foreign party, where in their dispute resolution, they would require a neutral mechanism or a neutral seat, right? So if you have a foreign party and an Indian party, and when they're negotiating their contracts, the Indian party would probably say, we want India as the seat, and the foreign party would say, we would want a third country. For example, if it's a Japanese party on the other side, and they would put maybe Tokyo as the seat, Indian party would probably put Mumbai as a seat, and then comes the option of what is the second neutral seat for both of these countries, would probably be amongst the top foreign seats in the world, and Singapore having that proximity with India becomes a natural choice. So I think Singapore has served, in terms of where there was a need, particularly for international contracts. And I think even when India continues to develop as a strong hub and a seat for international arbitration, in disputes relating where there is a foreign party and Indian party involved, there will always be a need for a neutral seat. And then there is the question, which is that neutral seat is going to be? Is Singapore serving that need or not? To my response, it very much is. It's been, I think, rather than looking at exporting, could those cases be done out of India? Would the foreign counterparty be comfortable to have them seated in India? Not because India is not mature enough, but because of the mindset to feel it's completely neutral in that sense. So I think it's a little bit of misconceived to say it's being just exported out, it's being given out. There is also a trend that I've been very closely following about Indian parties choosing India as a seat with SIAC as the administering institution, which is a growing number as well. In fact, about 18% to 18 to 20% last year were seated in India. So those are, you need an institution of an international gold standard. So you get that institution to administer those cases, but those are very much seated in India. So Indian parties, two Indian parties, or even where Indian parties have a stronger negotiating power, can choose India as a seat, take SIC as the institution. So I think there are different layers to even understanding this, including the concept of whether how many arbitrators are being appointed, right? Who would you appoint as an arbitrator in cases with a foreign party? Can you appoint an Indian as an arbitrator in those cases? You need a neutral third nationality. And therefore, you know, we've become sort of victim to our own success in that sense, because you've got so many Indian cases with the Indian party involved. You need to have a third national appointed on those cases, and therefore the statistics reflect a story that it does. So I think we need to understand it in a more nuanced way than to just put statistics side by side and say, oh, what is happening? Indian parties arbitrating in Singapore, which is not the case. It is there to support what the Indian trade needs. And I think that follows into your second question to whether mediation is a competition or a threat to arbitration. Why do we have these different mechanisms? It is to serve the needs, the commercial needs, right? It's not to make arbitration popular. That's not the underlying objective, and which is why Justice Somasekhar talked about the societal need. And I think at the heart of any enterprise is what is the value, what is the need that it is catering to. And both arbitration and mediation are serving to that commercial need to resolve disputes efficiently. Can mediation bring in its net all kinds of dispute and resolve everything efficiently? The answer is no, because there are so many different factors. There are emotions, we talked about egos, we're all of that. There are also types of disputes. Parties' objectives, their own mandates that drive their choices of dispute resolution. So our mediation cannot bring within its net, even though that may seem like the more ideal way because the parties' relationships are preserved. It makes more sense because it's less contentious. You know, in the societal norms, feels like the better thing to do. But the reality is not so uniform, right? It is this mixed set of disputes, mixed set of commercial realities. And then there are these arbitrations. So I think while mediation will continue to grow, and internationally we are seeing with the mediation convention coming in, we had about, I think, 58 signatories and 19 those that have ratified, which includes major countries like Japan who've ratified. In fact, in Japan, mediation is quite popular. When we go and meet Japanese parties, they're very serious about mediation. For them, it's not like just a step that they need to follow. For them, like when they choose processes like ARB, they put it in their clauses, make it mandatory that the parties would be referred to mediation after arbitration or before arbitration mediation. It's very much part of their clause. It's not just, you know, a compliance, so to speak. But that's also the mindset of certain countries where they look at it more seriously. I think India is gearing up with the Mediation Act. There's a lot more, I think, we're warm to mediation than before. There's a lot more seriousness. Even when I go and speak to companies, they're more serious about mediation now. You know, we've got this ARB protocol with SIMC, which means that the parties, when they commence the arbitration, they're referred to mediation. They try and settle the dispute. If they do, it's converted into an award, which means it becomes enforceable. And that's the gap, right? Till you have as many countries who are signatories to New York Convention sign up to the mediation convention or ratify mediation convention, you need something that will be able to enforce it, like the way you enforce an award. Till you give teeth to that award, that settlement, it's still in vacuum. You know, we're still talking it in theory, not in practical terms. So I don't think they are competitors. I think they're complementary. They serve, the larger need of the businesses. And that's the way we need to look at it. And I think SIC is very much working, with the parties to understand where it's in fact, you would have seen the revisions in the rules. The SIC revised its new rules. While in practice, that's not something that needs to be codified, but we have codified in the rules that once the case comes to the table in the first case management conference, the tribunal will nudge the parties to go and mediate. And it is recognized as the powers of the tribunal if they want to particularly adopt the protocol as well. So, these are the changes at an international level that the institutions are making to integrate mediation within the system to help parties that where they are serious about preserving relationships, continuing businesses, that mediation is something they can very much adopt within the same ecosystem and also give an effective, enforceable award at the end of the day.
So Shwetha, you mentioned ARB med ARB. Do you see any other form of ADR which is actually practiced abroad, which of course in India we may not be following, but which could also result in an effective way of settlement? I mean, there are concepts which are called as settlement conferences. There are concepts which are called as neutral evaluation or early neutral evaluation. Now, these are not concepts that we see. In fact, when I was looking up and doing some research on early neutral evaluation, I came across one case, and that case actually related to a masala company, Bawa Masala Company. The Delhi High Court in 2007, Justice Sanjay Kishan Kaul actually referred that IPR dispute for a early neutral evaluation. And I don't know the result of that, but there has been some movement forward, but somehow it's not taken off after that. Now, these are other modes of ADR which are actually practiced in other jurisdictions, and in some of them they are mandatory. Like the US, they have it in their ADR rules. The UK have it in their CPR rules. Now, we don't have it anywhere. Do you think, of course, we have a Mediation Act now which is lacking in some form, but do you think that there are these other forms of ADR, and I'm putting this question to you from an international institute perspective, that could really be the way forward to resolving disputes, which could be, of course, an alternate to litigation and, of course, even mediation to that extent?
I mean, with my limited understanding on these other forms besides arbitration, mediation, I think they are very structured, expert-driven. Also depend on the specific industries and kinds of disputes where they work well. So you do see it in international suite of dispute resolution mechanism, but if you were to match it against arbitration or other more popular, it is still fewer. And more, I think, technical sort of disputes where they work well, or very high value, complex sort of disputes where they work well. In some cases, they could be used as a part of the multiple suite of options in the tiered mechanism, or to hive off a part of the dispute. In fact, when you'd ask, you'd put this question, so there's a very interesting example which SICC has done with SMC, the Singapore Mediation Center. It's called Integraph, where they have integrated multiple dispute resolution mechanism, including neutral evaluation and interim adjudication, where they allow in fact, there's a neutral profession called signal person who helps to identify which part of the dispute should go to which mechanism. So, it adds to the toolkit for sure. And if India, were to adopt it more actively, it would certainly help. But I think just one word of caution and a caveat would be, it needs specialized training. And that I add to even the conversation of mediation. Mediation is great, but you need specialized trained mediators. Not everybody can be a mediator, right? Not everybody can be an arbitrator. So that training is very, very essential. So if we think of adding another mechanism to the toolkit, it cannot be without the training of the mindset, of the skill set, and sensitizing people, the parties who are really beneficiaries of these dispute resolution mechanisms?
I think we need to take baby steps in this area, because while we are grappling with mediation with the law that we have, I think going into other forms of ADR like early neutral evaluation. Now, early neutral evaluation is where you go to a retired judge or an expert and just make submissions who will give you an evaluation on the merits of your case and what are going to be the estimate of costs. Now, this is without evidence, without any trial. Just the parties are being made to realize that if you take this dispute to litigation, this is the expectation of the likely outcome and the cost that you will incur. Now, we don't see that too much in our part of the world, but these are things which are practiced abroad and to some extent successful. I'll now, since Shrivardhan is not been, and I would like to hear from the industry perspective, because the Bombay Airport, and I can say that as a matter of fact, since I have been representing the Bombay Airport since the privatization, and for the last 20 years, Janak has been my counsel in most of my matters where the Bombay Airport was involved. And the kind of issues that we face in the Bombay Airport, and for those who have traveled from outside the city and for those who are living in the city, of course, know that when you actually land at the airport, you see this whole encroachment of 300 acres of slum. That's one part of it. The second part is the high rises which are surrounding the airport. That's the second part of it. The commercial contracts and the issues relating to right of ways, every aspect of how development needs to happen in the city, since our airport, which was created in the 1940s and 50s, where Santa Cruz and Andheri were considered outside the city limits, has now become the center of the city. Now, that's why I wanted Shrivardhan on this panel, because as a party who's facing so many litigations and litigations on all fronts, how do you view mediation as a way of resolving your disputes? And do you see any success, or is it that you have to initiate the litigation process, or the other party initiates the litigation process? What happens in your disputes, and how do you look at mediation as a form of ADR?
Thank you, Farid, and thanks everyone for coming. Thank you, MCI, for inviting me. So, when I joined the airport side, I was not very familiar with what happens behind the airport, and I won't generalize, but I'm sure a lot of us wouldn't probably get a clear view of how airports function behind the scenes, and especially from the legal and litigation side. And Farid, of course, has a lot of experience acting for me so he laid out the pointers very nicely. From a perspective of airport, and generally as an organization who's obviously, not just operating, airport as a business for profit, but clearly it is an infrastructure project, it's a PPP project, and it is necessarily for the society and for the public, and at the same time, also a business, so to speak. So I think the onus on such infrastructure projects and companies like ours, especially where we have a stake of the Airport Authority of India government entity in the SPV, becomes very important how we handle our litigations and our disputes. So from that perspective, if I see mediation or any form of ADR is critical, because frankly, nobody wants to spend money on litigation. We always say as lawyers that, we advise our clients, you're spending good money behind bad money, but we end up becoming beneficiary of that good money as practicing lawyers or, other law firms, etc. But the point is, I think in an airport, there are so many stakeholders precisely talking about this organization. It's an ecosystem, right? And mediation or any form of ADR can only be successful if all the stakeholders who are involved in the airport come together and adapt or adopt a system like that. So it's not purely an ecosystem where two commercial entities are involved. Of course, we have our concessionaires and retailers who who are at the airport and are running a business for profit. But we have Airports Authority of India as one of our biggest stakeholders, and we have ongoing disputes for the last several years, and still disputes simmering with the AAI, which are large stake disputes, right? They may be involving land, involving revenue, which is under our concession agreement. We have disputes with employees, with people who are encroaching over airport premises. So, just taking a cue from the point Janak bhai made, that if we limit something like mediation, especially a formal mediation, only to commercial disputes, then we will not be able to widen the scope to other disputes per se. Of course, there is a reference to community mediation in the Mediation Act, but it is more like a better form of probably a local panchayat or societal disputes being evaluated and adjudicated in a society. So that really doesn't cater to these kind of scenarios. So I think, and in an ecosystem like airports, I can tell you personally from experience, the airport operator or the concessionaire or any stakeholder doesn't want to litigate, because it is an infrastructure project which can only run if everybody works together. Nobody is there for as a fly in fly out operator. So it is very important that ADRs like mediation and a formal mediation is adopted by the stakeholders in an ecosystem like airports, because it is a bit like two family members living under the same roof, can't see eye to eye, but have to sit on the table and eat their meal together, but still bitching about each other at the back. It's a bit like that. So it doesn't serve our purpose or a stakeholder's purpose if we are fighting in a court or in arbitration, but at the same time we have to work together, right? Unless, of course, it's an extreme situation where one party is completely on the wrong side. So it is an important tool, and I think as MIAL and as a group generally, I can say we have some examples where as a group also we have encouraged mediation with even with international parties, and have had success recently in one of the mediations where a US mediator was involved, and it was an intense mediation of 2 or 3 days, and it was resolved successfully. But just coming back to your point again, Farid, just to conclude, I think it's important that every stakeholder in an airport ecosystem and any infra project, including government entities, view this seriously. In fact, Airport Authority of India have their own rules for mediation. They have something called AI mediation rules, but frankly, in my last 2 years, I have not seen AI using that to their benefit or just to resolve issues, very frequently. And there are fairly decent rules, to be honest. But I feel if entities like an organization like Adani or any other large corporate or government on the other side, if these kind of institutions and conglomerates encourage mediation, it does give a boost to smaller parties, relatively smaller parties, and generally to the public and to the stakeholders, to say that yes, if government is entering into ADRs like mediation and taking it seriously and abiding by it, of course, compliance is probably more important than the process, I would say, then it could take all of us a long way in this format.
Since you mentioned mediation both domestically and internationally, do you incorporate these clauses in your contracts on referring the dispute to mediation as a precursor to any other dispute resolution, or do you voluntarily try and approach the party to participate in a mediation process? Because under the Mediation Act, you need to have a written agreement. So how do you kind of get involved in the process as an industry player? Do you have it in your contracts, or do you reach out to somebody before the dispute arises? How do you go through this process?
Right. So just on that point, and I was listening to what Janak bhai said and Shwetha said on exporting arbitration. I think I'm pleased to say that we are more vocal for local. at the airport and at Mial, we don't have SIAC or foreign arbitration clauses in our contract, but that's also because, as you said, most of our contesting parties or opposite side are Indian parties. But on a serious note, on what Farid asked, so we don't necessarily have a mandatory mediation clause under the Mediation Act. But yes, as most of the agreements have, we also do have a pre-arbitration negotiation or conciliation clause. But I just feel, practicing for so many years and then now in-house, and we spoke about other forms of ADR. My view is that what nomenclature you give to the ADR mechanism or what process do you follow as an ADR becomes immaterial beyond a point if both parties have the right intent to resolve the dispute, right? Because Mediation Act has only come in 3 years ago. What were we doing before that? And most of us have been practicing, I'm sure, for more than 15, 20 years. So it's not like parties were not resolving disputes before this. So a lot of clauses, including our agreements with the government entities, don't have a formal mediation clause as such. But what is important is whether the pre-arbitration, pre-litigation provisions are being adhered to and are taken seriously. The way courts are now pushing and under the act or otherwise for the parties to go and resolve their disputes. There has been jurisprudence earlier in our courts on the pre-arbitration clauses, whether they are mandatory or voluntary, and the courts have taken different view on whether they are mandatory or not. And I personally feel they should be mandatory, otherwise what's the point of having those clauses? The conciliation may fail. So whether we call it conciliation or negotiation or mediation or intergraph or any of that sort, I think it's important that the parties adhere to it. And yes, our agreements do have those clauses. We do follow that mechanism. But sometimes, formalizing a mechanism like mediation becomes important because then the parties, I suppose, take it more seriously as opposed to an informal negotiation and with an expert or an appointed arbitrator or a mediator. It just becomes all the more process-driven and formalized in that sense and ends up into an agreement. So that's something that we will be looking into in our future contracts.
Thank you, Shrivat. I just want to, ask both Janak as well as Justice Kureshi, because both of them, and I know Justice Kureshi has done far more mediations than, in the room that we are in. But I'd like to ask both of them, because what positive role can lawyers play in this process to make it successful? I mean, as a part of the ecosystem, I think lawyers have a very crucial role, but as mediators, and I know Janak has not had too much success being a mediator, but in his experience, and I'll first ask Justice Kureshi and then Janak can take up that question, that what is the role or a positive role that a lawyer should have in mediation?
Lawyer's role starts even before the mediation starts. As I said, find the correct matters to go for mediation. Sending all and sundry matters really does not help. As I said, immediately the lawyers can see through it that here is a chance of settlement. So first, selecting a correct matter for sending for mediation, that's where the lawyers have are in the best position to say. Throughout the mediation, the lawyers can guide their clients correctly. That's another extremely important role, because very often, even the industry people, when they come for mediation, there is some sort of apprehension, slight hesitation, what this process is. And those who are not from industry, those who are not so experienced, come with a lot of trepidation. Who is this retired Chief Justice? Is he going to decide something? Are my rights going to be foreclosed? Do I say something, it will be held against me? So lawyers can constantly guide them, put them at ease, and also say that every stage, whatever you say before the final decision is taken, you will be guided as to what you are doing is correct or incorrect. Should we go ahead with this or should we change our strategy? So that's constantly guiding the client all throughout the mediation process is an extremely important role. Sorry to say, sometimes I have come across cases where the lawyers do not want the mediation to succeed. Not many cases, maybe less than 20%. Most difficult part for me is how do I tell the client that don't go blindly by the advice of your lawyer. But that's a very small element, so I don't really worry much about it. And last is how to prepare the settlement terms. In one of the cases, Janak bhai, everything was settled, only how to write down the settlement, it failed. Parties could not decide. They've decided how to settle it, but they could not decide how to write it down. And it's failed. It was tragic. So lawyers can guide them. And what I tell the clients is that, look, international contracts are prepared with input and expertise of battery of lawyers. But if somebody wants to sabotage it, it's possible. So don't go by writing everything. You cannot protect your contract by writing down everything. The intention to carry it through should be there. So, to my mind, 3 important stages. Pre-mediation, find out correct matters. 2, all throughout, guide the client correctly. At the end, be positive and cooperative in writing down the settlement terms so that it doesn't go into unnecessary complications. Thank you.
Janak?
I would totally agree with Justice Kureshi. He couldn't have put it better. I think lawyers are really the people who can inspire the confidence required from the side of the litigant to undertake a mediation process. And holding the hand of the client through the process is extremely important, because it may be something the clients are not used to, they may not be aware of, they do not know how it works, they don't know the process, they don't know the outcome, and they don't know how enforceable or otherwise the final outcome may be. So I think the guidance which the lawyer can give and the confidence the lawyer can inspire in the client is extremely important. Of course, that happens by and large when the lawyer himself is not insecure. And I mean insecure in that way, where he doesn't think that by going through the process or pushing the process of mediation and settlement, he is likely to lose out on a lucrative brief. So I think that unfortunately, Justice Kureshi said happens, but happens probably in lesser number of cases than the number of cases which do really get settled. But it is important because, and that's where, according to me, how savvy the client is also plays a huge role, because the client should be smart enough to know whether his interests are really being protected or is he being encouraged to do something which may not be in his own interest. The third, of course, is where the lawyer tries his level best to encourage the client to go down the right path, but the client, as Justice Kureshi earlier outlined, for one of these 4 or all 4 reasons, would not want to go through the mediation process. There again, I mean, short of holding a threat like I did yesterday, and I told my client that, look, if you're not going to give me authority to settle and mediate, then I don't mind giving up the brief and walking out. You know, it's enough is enough. I think you're being really stupid in trying to prolong this dispute. So sometimes you have to use those methods. And very often the language I speak, many of my juniors will vouch for it, and many clients too, where I tell them that you may think that you're contributing to the welfare of the legal profession by coming to people like us, but I can tell you there is a queue of people waiting outside the door who look after my welfare. You don't need to worry about it. I am telling you, this is not a dispute you should be fighting and litigating about. It's in your interest to settle or bring about a resolution. So yes, according to me, lawyers do play a very important role.
I think we have just this much time. Do we have time for a question or two? Niti?
Farid, sorry.
So we'll just take... So let's not take any question. People can just reach out to any of us outside. Justice Kureshi and Janak have to also, get on with their professional engagement. So thank you very much, everybody. And it was delightful to, speak in front of all of you. Thank you.
Sorry.
Just before that.
Just one point.
One point.
Sorry, just a last point. I think in addition to the 3 points that Justice Kureshi mentioned, the first step starts with in-house counsel, I believe, on a mediation mechanism, because we as in-house counsel have to advise our business stakeholders that you start with negotiations and then reach out to us and then we reach out to the external lawyer. So I think that is equally important and that's where the first step starts.
Thank you.
Thank you so
Shwetha.
much. Thank you, everyone. And sorry I have to